I'm sorry, good morning. I guess I probably need to address everybody first. Good morning. Before we begin, I've asked Commissioner Figueroa to lead us in a word of prayer.
Gracious God, thank you for today. Thank you for waking us up. Not everybody got woken up, and Father, we mean that they have a purpose. So may we drive to that purpose when we do your will. May we be diligent about it and full of grace in all we do. In your name we pray. Amen.
Amen. It is 8:35. The meeting of the Texas Commission of Licensing and Regulation will now come to order. Tamla, will you call roll, please?
Mike Ayers-Mendez.
Present.
Tom Butler.
Here.
Ray Callis.
Here.
Helen Collier.
Here.
Rick Figueroa.
Here.
Gary Weston.
Here.
Deborah Yurko.
Okay, thank you. We do have a quorum present. At this point in time, a motion would be in order to accept the absence.
So moved. Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Move on to item C, if there's anyone here for public comment on an item that's not on the agenda. If it's on the agenda, we'll take that up at that point in time, but if you'd like to speak to the commission, we will grant 3 minutes for you to speak. So just come on forward and be able to speak to the commissioners at this time. Seeing no one, we'll move on to item D. We will not have an executive session, so let's move on to item F. Approval of the minutes. Commissioners, I would point out to you one item that we noted on the minutes. I believe it stated in the Ruiz case that the motion for a hearing was granted. There's a correction there. It should state that the motion for a hearing was denied, but there was a modification to the order. And so the new minutes that have been corrected reflect that, so I would make note to you that the minutes have been changed, but when you read the Ruiz case, that it was not granted. It was actually denied, but we did modify the order. Any other corrections that you can see? If not, a motion will be in order.
Make a motion to move these minutes.
We have a motion, second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. We'll now get to our cases. G1. It looks like Avelli's Engaged Record Service. We do have, is it Rachel? Come on up and have a seat up here. The Toyas, is that right? The Toyas? Oh, that's an H. I'm sorry. I thought that was a T. My apologies. The Hoyas. Have a seat up there. Morning. Go right ahead.
Good morning, Commissioners. My name is Jessica Hurtado, and I am a prosecutor with the Enforcement Division. I ask that you adopt the administrative law judge's proposal for decision and assess a $2,000 penalty against the respondent. The respondent is a vehicle storage facility that accepts vehicles 24 hours a day. The complainant's vehicle was towed from the scene of an accident and stored at one of respondent's 4 locations. When the complainant contacted respondent to claim the vehicle, the ALJ found that the respondent refused to help the complainant locate his vehicle. As a result, the complainant had to wait an additional 2 days to release his vehicle. The ALJ found that this delay resulted in additional charges that posed a financial hardship to the complainant. The ALJ concluded that the respondent failed to make the vehicle available for release to the complainant within 1 hour as is required. The ALJ recommends a $2,000 penalty for 1 Class F violation. I ask that the Commission adopt the PFD as written, and I'm available to answer any of your questions.
Any questions for Jessica? Mr. Hoyas, this is a case that was heard before a ALJ judge at the SOA. We can only take into account what was stated at the hearing. Anything outside of that, the prosecutor or general counsel will stop you and let us know that that wasn't heard in the case, so we're not allowed to hear it here. So if you understand that, if you don't mind, state your name for the record. If you don't mind speaking closer to the microphone, please.
My name is Rachel De Hoyos.
Please proceed.
I just want to comment that I think this case is based on just he said, she said. There's no evidence that states that that it was a fact that what was said between me and the person calling on the phone, and that is all that they're basing that on. The complainant never showed up to the property. It states in the rules that that person has to show up when you make an hour's notice. The complainant did not make an hour's notice to pick up the vehicle. The complainant wasn't present, and I was the one that answered the phone 24/7 that whole weekend. I released 34 cars that day, that weekend, I'm sorry. And so I find it very hard to believe that they would feel that I didn't release that one vehicle that whole weekend. And I did provide proof to the state that what vehicles I released that weekend.
Mr. Hoyes, the judge found a preponderance of the evidence showing that you refused to help him locate his car. Of the 4 locations that you had, the ALJ states that based on the preponderance of evidence, showed that Ms. De Hoyos refused to help him locate it when he called on Sunday. So she found enough evidence there to say that you did not provide it for him.
The issue was the hours release, and nothing was mentioned about the location of the vehicle.
Any other questions for Ms. De Hoyos? Just so you know, I can tell you, based on what you just said, that's still not enough for me to overturn what the ALJ has stated. You haven't told me anything. So,
All I can say is, you know, I provided the state with the released vehicles for that whole entire weekend.
And
we
I would
released-
just say that that's not in the record.
anything else?
Why not?
Was it not allowed by the ALJ? If it wasn't allowed by the ALJ, then that's the reason it's not in the record.
I'm not sure. The state didn't present it.
She didn't offer it at the hearing.
Neither did they.
It's your responsibility to offer evidence, not the state's responsibility to offer evidence for your behalf.
They required it for me to enter it.
Did you offer that evidence in the case? Then we cannot hear it here. Okay? You have anything else for us?
Well, I just, you know, the statement that made that it's a known fact, I'm really kind of trying to understand where they find the fact that I said it wasn't available. That's the part that I don't understand.
That was a question you probably should have brought up at the case in front of the ALJ and asked that question.
I did bring that up.
Then
And that's what I'm
if the
saying. It's
answer
a
that
he
you
said,
rec-
she said, and I don't understand how come they're taking that side.
If the answer that you received from the ALJ was not sufficient, you've, of course, taken the next step to us. I can tell you on my part, you haven't provided any evidence showing anything to the contrary, so I don't see where anything should change on my part.
Well,
So
there isn't any evidence. That's what I'm saying. It's a phone call.
obviously, obviously the prosecutor provided enough evidence to the ALJ to show that you were in violation.
A screenshot of a phone call.
It was enough for the ALJ to show that you were in violation.
And we get phone calls all the time.
All I
That's
can
the
tell
part I
you
don't
is that it was enough evidence provided by the prosecutor at the SOA hearing that the ALJ found that you were in violation of a state law. So, or a rule, I'm sorry. And because of that, they fined you $2,000. Now, of course, you take the next step, which is a 42U. This is it. And so, I mean, if there's anything else that you'd like to present to us, then we can hear it. And if there's any questions the commissioners have, they can ask you. And if not, then we'll rule on it. Any questions?
Mr. Chairman, I recommend we adopt the PFD and issue by the ALJ, because I have not heard anything that's going to change my mind either.
We have a motion.
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. The staff will be in contact with you. There is the opportunity for you to have another bite at the apple before you can move it on to the district court level. So they'll be in contact with you and tell you kind of what your next steps are.
Okay.
Thank you.
Thank you.
Item to number G2, Danny Loya. Is there anyone here representing Mr. Loya or Mr. Loya himself? Morning, sir.
Good morning, Mr. Chairman.
Go right ahead.
Good morning, Commissioners. My name is Ken Sharp. I'm an enforcement prosecutor with TDLR. The applicant for a license in this case is Danny Loya. He applied for an apprentice electrician license. The administrative law judge recommends that you deny that application. In 2016, Mr. Loya was convicted for the offense of interfering with a police service animal. The court sentenced him to 40 days in the Travis County Jail. Now, also in 2016, he was convicted of 3 separate counts of burglary of a motor vehicle, and he was sentenced to 40 days in the Travis County Jail on each one of those. In January of 2018, he applied for the apprentice electrician license. Now, that license application asks if the applicant has ever been convicted of a criminal offense other than a minor traffic violation. He answered no, in spite of his convictions. Now, the offense of interference with a police service animal, that's not listed in our guidelines as a directly related offense. But it did occur less than 5 years before the application, so Chapter 53 of the Occupations Code authorizes reference to that as a basis for a denial of the license application. Now, the 3 burglary of a motor vehicle offenses, they are directly related because they're property crimes or crimes against property. So they do offer a direct and specific authorization for the denial of the license. The ALJ recommends that you deny Mr. Loya's license application, and the department asks that you adopt a PFD. Thank you.
Any questions for Mr. Sharp? If not, a motion will be in order.
So move.
Second.
A motion is second. All in favor, signify by saying aye. Aye. Those opposed, motion carries. Item G3, Thomas Walker.
Morning.
Morning, Trevor.
Morning. Trevor Thielen with the Enforcement Division.
Is anyone here with Mr. Walker, representing Mr. Walker? Mr. Walker himself? Go right ahead.
Before I do my presentation, our general counsel's asked me to put a few things on the record about procedural matters in the last couple days. On July 9th, the applicant's attorney, Mr. Frank Thompson, called our general counsel and informed them that they couldn't be here, and they were given the opportunity to file a motion for continuance. Mr. Thompson told GC he wouldn't be doing that because they wouldn't be at any future meetings. He asked if he could submit a letter to be presented to the commission in lieu of appearing, and GC offered him that opportunity and set a deadline of yesterday, the 19th, to submit that letter. And they also gave him the general counsel main email address to send that letter to. On Wednesday, Mr. Thompson sent an email instead to the Open Records Division saying that he would like somebody to call him. And that email was forwarded to Janet Redfern, who was out on vacation, as well as myself yesterday about 12:21. So I asked my legal assistant to call Mr. Thompson back and remind him that the deadline was that day to submit the letter. So she called him at 1:13 p.m. yesterday, and he basically wanted to reiterate their case. She reminded him about the letter. He interrupted her, continued to make his case, and when she tried to remind him again that, hey, you've got to issue this letter today before the end of the day, he hung up on her. So that's the last that we heard from Mr. Thompson. I don't believe it qualifies as a motion for continuance, but wanted you to be aware in case there's a motion for rehearing down the line.
Thank you.
I represented TDLR at the SOA hearing against Thomas Walker, where the department presented uncontroverted testimony from 2 witnesses, along with documentary evidence, which showed that Mr. Walker contracted to perform unlicensed ACR work. The ALJ found that Mr. Walker submitted a quote for $1,500 to install a new 4-ton furnace at a customer's house, and that the department met its burden to prove a violation. The ALJ agreed with the department's recommended $3,500 penalty based on the following evidence. Mr. Walker, both personally and through a worker that he brought to the customer's house, actually performed and received payment for the unlicensed ACR work he bid for. While performing this work, either Mr. Walker or his helper punctured the home's ACR evaporator coil. Mr. Walker never repaired this hole or paid restitution to someone else to repair it. After the customer discovered Mr. Walker was unlicensed and tried to call him numerous times to discuss the issue, Mr. Walker ghosted the customer by both refusing to answer or call back, and sometimes by answering and then hanging up once the customer started speaking to him. While at the customer's house, security camera footage captured Mr. Walker stealing a specialty light bulb worth $65 from the customer's lamp. After the customer complained to the police, Mr. Walker denied stealing anything. However, the bulb was returned to the customer's doorstep the next morning. Customer had to pay a second contractor $1,000 to complete the work and repair the damage to the coil. This second contractor determined that the respondent's work was, quote, jerry-rigged and could have caused a fire. Though the department had no prior complaints against Mr. Walker, both of the department's witnesses testified about personal knowledge of prior instances where Mr. Walker performed unlicensed ACR work. The department recommends you adopt the PFD as written. Do you have any questions that I can answer?
Any questions for Trevor?
No questions. Move
Motion
to
to
adopt the
adopt.
PFD as written.
We have a motion?
Second.
Second, all in favor signify by saying aye. Aye. Those opposed, motion carries. Item number G4, Commission, in this particular case, you have an email that has been given to you, a copy, where he has requested a motion for continuance, stated that he's in a custody battle, he's got a scheduled vacation with his daughters at this point in time, and they've asked for us to reschedule. I believe that the prosecution has no objection to it.
That's correct. We don't oppose.
So if everyone's okay, we'll move this to our next meeting in September.
Sure.
Sounds great. Thank you. Appreciate it. Let's go on to the motions for rehearing. First one is Texas Nails and Spa. Doug.
Good morning, Chairman, Commissioners. Doug Jennings, Assistant General Counsel for the Department. Mr. Chairman, have we inquired if the party
Oh, I'm
is
sorry.
present?
Is anyone here representing Texas Nails and Spa? Go right ahead.
All right, thank you. This matter resulted from a default order in which the Department assessed administrative penalties against the respondent totaling $1,750 based on the respondent's alleged failure to clean, disinfect, and sterilize manicure and pedicure tools and failure to clean and disinfect a Whirlpool spa. The respondent's motion for rehearing states that she was not properly notified of the case because documents related to the case were not mailed to her home address on Zachary Scott Street in Austin. She also claims that she sold her business in December 2017 and states she never received the case documents mailed to the business. We have reviewed the record, which shows that the first notice of alleged violations was in fact sent to the respondent's residence on Zachary Scott Street, and that notice was returned to the department marked return to sender, vacant, unable to forward. As a result, the Enforcement Division sent a amended NOAV to two other addresses, one to the address of record for the respondent's cosmetology salon owner license, and additionally took a step of having notice delivered to the physical location of the respondent's business. And so we have confirmed that notice was proper in this case, and that the Enforcement Division, seeing that the notice was returned from the respondent's residence, took extra steps to make sure that notice was sent to further addresses. So we believe no error has been committed in this case, and we would therefore recommend denial of the motion.
So,
Any questions for Doug?
so full due diligence, obviously, with attempting to get the documents there. When you mentioned that the first one in a situation where it was returned, location vacant, is that correct? Which address was that?
That was her residence on Zachary Scott Street in Austin. And it was interesting because that was where the first NOAV was sent. And the respondent's motion for rehearing doesn't just say, I never received notice. It specifically says, I didn't receive these documents at my home address on Zachary Scott Street in Austin, and provided the number, but I'm just omitting that for for convenience. And it seems that after the department discovered that didn't seem to be the proper address because it came back, the NOAV came back marked vacant, they took additional steps. Stopping there would have been legally sufficient, but they took additional steps to make sure the respondent was served at additional addresses. And so I believe more than due diligence was done in this instance.
No further questions, Mr. Chairman. I move that we adopted PFDA as presented.
Okay, let me kind of refine this. Let's back up a little bit. This would actually be to deny the motion for rehearing.
Yes,
I guess,
thanks.
Commissioner Kelly, that'd be your motion, correct?
Thank you.
Okay.
Deny the motion.
Second.
We have a motion and a second to deny. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item G2, anybody here for Reels towing? Yes. Okay. I'm going to need you to fill out a form that's located over there on the desk, if you don't mind picking those up. While they're doing that, anyone here for Andy's Record Service? Okay.
I do believe the respondent is here for that. For the
Andy's
other-
Record Service? Andres Ceballos? I don't see anybody.
Yeah, he was here a few moments ago.
There he is.
Yeah.
Oh, let's make sure that he fills out. Are you here for Andy's? Okay. You don't mind making sure you fill out a form? You can go in and sit up here, sir, if y'all would like. Just fill that out, and then at the end, you can just hand it to me. And if you're both going to speak, I need for each one of you to fill one out. So I don't know if you're both going to speak.
I think that'll just.
Okay. Go right ahead, Doug.
All right, thank you. This matter resulted from a default order in which the department suspended respondents' licenses, tow and VSF licenses, and assessed administrative penalties against the respondent totaling $7,100 based on the respondent's alleged failure to keep the required amount of liability insurance for a vehicle storage facility, failure to enclose the facility with a fence, and failure to ensure that the tow company kept liability and cargo insurance for each of its trucks. The respondent's motion for rehearing states that the respondent never received the notice of alleged violations in this case. However, the department sent the NOAV to the respondent at her last known address as required by the APA. The NOAV was sent to 145 Canvas Back Cove in San Marcos, which has been the respondent's permanent mailing address of record since 2012. And so we would say that allegation of error is without merit. I'd just like to bring to your attention that on May 2nd of this year, respondent made an initial payment of $5,500 and entered into a payment plan with our office to make additional payments of $400 beginning in June. And so the respondent is current on that payment plan. I've consulted with the respondent's attorney, and they're aware that we're just recommending probating the suspension in this case. Of course, that's up to you, but because the respondent is current on the payment plan.
Okay.
And denying the motion.
Denying the motion, but go ahead and just probating the suspension. Any questions for Doug? I can tell you, I'm not opposed to that. I think that as long as they're staying current with the payments, I don't think it's any problem for me to probate the suspension. So,
Have there been any other violations or where's the history?
it would be based on the fact that they continue to maintain and not have any other violations during that time frame. That's correct. So, if you don't mind, hand me that form right quick.
I haven't filled it out yet. I was
Oh,
waiting
okay,
to speak
okay.
and just upon
Sure,
conclusion.
Now, let me tell you right quick. In this motion for hearing, the only thing that you can bring to the commission is tell us where we erred in coming to the decision. Was this
That's my
is
understanding.
this a default order? This is a default
sir.
order. It only come to where the executive director may have come into an error in coming to the default order and signing it. And you have to keep it to that and not go into the details of the case. Understand
That's
that?
yes, that's my
Okay.
understanding, and my intention right
If you
now
don't
is
mind,
just to
go
make
ahead
a
and state-
pro forma announcement of my name, actually.
State your name for the record.
My name's Anthony Fusco. I'm with Surgeon and Associates, and I represent the respondent,
Okay, go
Barbara
ahead.
Carmona. And as the General Counsel's office just stated, that's my understanding of the agreement. Ms. Carmona is current and meeting the terms of her agreement, and that is my understanding of the recommendation.
And you would
I-
accept that recommendation?
Yes, I would, and I would ask the panel to respectfully to accept
Okay.
that. And that's all I have at this moment. Thank you.
Commissioners, a motion be in order?
Move to deny the rehearing, but accept the probated
Suspension.
suspension as long as they keep payments.
Okay. We have motion and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank
You
you.
got your suspended probation, so you're good. If you don't mind, fill that out and just bring it back to me. Or actually, you can probably hand it there at the end.
Thank you.
All right? Thank you. Appreciate it. Let's move on to item 3
I know, but that's
for Andy's Record Service. Come on up here and have a seat. Go ahead, Doug.
All right, thank you. Again, Doug Jennings, Assistant General Counsel. This matter resulted from a default order in which the department assessed administrative penalties against the respondent totaling $3,000 based on the respondent's violation of Section 85.726 of the VSF rules, which requires the licensee to conduct VSF operations with honesty, trustworthiness, and integrity. On or about November 18th of 2016, respondent allegedly accepted a 2013 Chevrolet pickup truck for storage at its facility in Belleville, Texas. Respondent then knowingly damaged or disassembled the vehicle or its parts in order to obtain pecuniary gain by dishonest means, and this conduct has resulted in a criminal conviction. Regarding the respondent's motion for rehearing, I will simply state that it does not meet the requirements of Section 2001.146G of the Administrative Procedure Act, in that it does not identify any error in these proceedings whatsoever. The motion simply states that respondent is confused, thought that a trial had taken place, and would like to request a rehearing. But as an extra measure, I reviewed the file. We did serve the respondent at the proper address, and he did not request a hearing during TDLR's process.
Any questions for Doug? Mr. Ceballos, I think you understood what we were talking about earlier, that you can only bring up where you believe that the department made an error in issuing the default order.
Right.
And kind of go from there. So make sure you confine your comments to that. If you don't mind, state your name for the record.
Yeah, Andy Savas.
Proceed.
So there's 2 cases on this same vehicle that I'm dealing with. They're trying to take my license. So I do have a lawyer, and we've been going to another court, and I sent this to him, and I guess that we thought they were both going to be combined instead of separate.
When you say going to another court, are you talking about district court, or are you coming to the SOA hearings?
We went to another place, and I talked to this other guy behind you, but
I can help out if you wouldn't mind. It looks like there was a SOA proceeding for revocation.
Okay, so
of the
there's a SOA
respondent's
proceeding
license
occurring right now.
that their PFD has been issued.
Okay.
In that recommending revocation of the license, and this commission will take that up at its next meeting.
Okay.
So he is correct that there have been two
separate cases?
Yes, this case and then the SOA case on the revocation.
Okay.
Yeah.
And and you just assumed that these two were combined?
Right. Yeah. I don't know why that they would have been separate.
I think there were probably 2 separate violations.
This is an administrative penalty based on the criminal act, and then the SOA case. This is a default, and so this is administrative penalties. And so the PFD was just issued in the SOA case, which is the revocation. And I'll defer to Ken Sharp to correct me if I'm wrong on that. So this is the default just for the administrative penalties. The other proceeding is the SOA case for revocation.
But it's still the same case.
They arise from the same conduct.
Correct.
That's correct.
Okay.
Okay.
Do you understand that, Mr. Owens?
No, it's the same vehicle that we're talking about.
So you have a license, and the allegation is that you engaged in a criminal act. And so today we're here for the criminal act. The SOA is for your license. Do you understand that? They're 2 separate processes taking place.
Yeah, I do now, but at the time I had no clue that.
And so we're alleging that you never responded to the allegations of the criminal case, and that's what brings us here.
Right, yeah, and so whenever I got this other letter from y'all, then I called my lawyer, and he told me to send this letter because I only had so much time to send it in, and I thought he was going to be here, so I was really confused on what I was really doing here. But if I could have a rehearing on this, I could discuss my side of the story and show all the proof that I have.
That'll take place at the SOA hearing. It's kind of too late at this point for this particular aspect of it.
Mr. Butler, if I may, the SOA hearing has already occurred for the revocation, and a PFD has been issued. And so on the administrative penalties in this case, the motion for rehearing we are arguing is not sufficient to be before you today because it doesn't present any allegations of error. But as our policy has been to bring these before you, And so we believe, it's our office position, it is too late for the respondent to be alleging any error in the administrative violations case. In future proceedings, he may allege error in the SOA case, since the PFD has been issued, and you'll be deciding on that at your next meeting. And of course, we'll have a motion for rehearing opportunity after that. But as to the administrative penalties, it was a default, and there's been no error. And so it would be our recommendation that you deny.
So the issue at hand is that you were notified and you did not respond. And then when you did not respond, that's when the default order took place.
Right, because, I mean, I didn't respond because we were already going to court, and
Yeah, well,
I mean,
and
I don't understand.
while I understand that that's the way you're thinking, that you did correctly, the fact of the matter is, according to the rules, you should have responded back to us, or your attorney should have responded back to us, so that you could move into a SOA hearing if you so chose to combine it together. In this particular case, you did not respond back to us.
All right,
I mean, because you received the letter from us, you received the NOAV from us, telling you that we're notifying you that there's an alleged violation,
Right.
and you never responded back to us. So,
yeah, I mean, I just submitted, I mean, I gave all this stuff to my lawyer, and I don't know what happened after that. I mean,
yeah, and I apologize for that, but obviously, we did not get notification back.
Yeah. So the attorney has been in contact with the office?
I have not been in contact with the attorney. When I reviewed the files for this case, I didn't see any correspondence from an attorney, at least requesting a motion for rehearing.
Did you have an attorney at the SOA hearing?
yeah, I had a guy that, yeah, I mean, I need to do something different with this guy, because, I mean, this is my livelihood, and, I mean, he's really making it difficult. I mean, I tried to get a hold of him for the past 3 days to figure out, is he gonna be here, or what was this about? Because I thought this was about the same thing until they gave me all these papers. So,
Right.
Yes, sir.
We could just hear it on September.
You begin to
29th.
start, at some point in time, questioning your legal representation.
Will we get that SOA PFD next meeting?
I believe so. Yes, sir.
And that's where we could probably
Yeah,
address
we
it.
could just hear everything at the same time.
Mr. Chairman, in order for him to feel like he had a fair due process, is there any way we can pick up both of these at the next hearing in order?
In the meeting that we will have in September,
It's for
we will take up the
revocation.
PFD. This is
Correct.
a motion for rehearing, so they're two still separate issues.
Well,
I
guess-
think he's
And so-
totally, I think he's been represented completely badly.
I
And
agree.
we're not here to debate that.
Right.
I'm just want to make sure he feels he's had his due process.
I think the way it's set up, it'll take a while before these catch up with each other, because this will be remanded back while we, at our next meeting, sounds like we'll probably get the PFD of the revocation,
okay.
and this one, the administrative will already been back.
If I may, effectively, if you do not rule on the motion for rehearing today, it will be denied by operation of law before your next meeting.
Okay.
And so your options are to grant or deny the motion for rehearing today. Of course, I would strenuously recommend denial. Or if you just don't take any action whatsoever, it'll be denied, I think, within the next 30 days, I believe, by operation of law. I don't have the exact date, but it will be well before your next meeting.
Can we roll this over to the next meeting so we can consider both at least?
No, it'll be gone. The timeframe will be up by that time.
Okay.
100 days, right?
Yes, that's correct.
So 100 days will be up before our next meeting in September.
Yeah, it still gives enough.
So we either have to,
Yeah.
I think in my opinion, is to grant the motion for hearing or deny it. Those are really our two choices.
Do you have any evidence as to why we should go either direction? I mean, I guess one direction favoring you, but
yeah, I mean,
you received the notices, you just,
right, I mean, I received it, and I passed it on to my attorney, and, I mean, I thought that everything was gonna be together because they were trying to take my license, and I don't understand if they take my license, I mean, I have to still pay the fine. I mean, that's why I got a lawyer, because I don't know nothing about this stuff, so I would think that he would do that, but, I guess you get what you pay for.
well, we have to decide. We can still grant allow him to keep his license down the road. That's a decision for another day.
Yeah, that's a different day. This is just talking about the,
Mhm.
yeah. So a motion will be in order for either granting or denying the motion for hearing at this point in time.
Make a motion, we deny the hearing, motion for rehearing.
We have a motion to deny.
I'll second.
Second. All in favor signify by saying aye. Aye.
No.
Tamara, could you do roll call, please?
Tom Lovett,
Aye.
Ray Callis,
No.
Helen Collier,
No.
Rick Figueroa,
Aye.
Gary Wesson,
Aye.
Chairman.
Aye. Motion carries 4-2 to deny. Staff will get with you. Basically, what's happened is that we did not allow the, we denied your motion for rehearing in this case. So they'll kind of step you through the next process of what you need to be doing. Get with your lawyer or not.
Yeah, I mean,
It's up to you.
yeah.
And kind of go from there. But we still have another case that'll come before us, probably in the next meeting, is the PFD from the SOA hearing. So
So
it's
I'm gonna have
not,
to come back
unfortunately,
here?
it's not well, that's up to you. We're not going to tell you to be here, but yeah, it sounds like we will probably, they'll notify you if it's going to be in our next meeting. It sounds like it probably will, because our next meeting is not until September. So there's plenty of time to get it on the agenda for that time. So staff will get with you and kind of talk to you, step you through that and let you know what's going on. All right? Appreciate you being here. Thank you.
They're gonna do that today or over a period of
Probably
time?
not. They'll probably just reach out to them.
That's fine, yep.
So where do I need to go?
Yeah.
Staff will get with you probably later on, next week. That's,
Mr. Chairman, we'll grab him after this meeting.
Yeah.
We'll
Right,
grab him out
okay.
in the hallway and let him know.
So-
Next episode.
Oh my God.
Thank you.
appreciate it. Thanks. I think you've got someone coming around to talk to him. Is that what they're doing? Hey, Ken, are you coming around to talk to him? Somebody coming around to talk to him? Okay. Lindsay's going to talk to you about that. She's right there. She'll take you out and she'll kind of let you know what's going on. All right, thanks. All right, that takes care of our motions for rehearing. Real quickly, I do want to do a couple of quick things. I want to thank our DPS officers for being here today. Thank you for helping us out. I also do want to make note that this is Kay's last meeting. She will be retiring September 1. I'm glad you're standing right there so the whole camera can see you. So she's retiring. And so in our next meeting, she won't be employed with TDLR any longer. But just so you'll know, Commissioners, I've asked her to come back in our September meeting. I want to formally and ceremonially send her off on her retirement. So she said if she could find time in her busy schedule, she'll come back. So, yeah, in her jet setting, going around everywhere, she'll come back. So Kay has been with the department for 21 years. I was going to say 23, 21 years. So, yeah, total state time of 30 years. So she's put in her time. It's time to enjoy. So she has been a pillar for the commissioners. She has been, for the last 13 years, it's been the person that I've talked to every single time I needed anything. So she's the one that kind of makes things happen. For those that don't know her, she has a vicious wit, a humor that it's, you know, you look at it and you're like, surely not, but boy, I tell you. I've seen it come out a time or two. Actually, it came out yesterday a time or two. So she will be sorely missed. Tamala, of course, is taking over her duties. So new commissioners will be starting off with Tamala, which is going to be good, but we're going to miss Kay. I just want you to know. So, but she'll be back in September so we can formally do this all over again. So I think by that time she'll probably be tanned and
A little more rested.
yeah, a little bit more rested. So thanks. Actually, we're about to move into that. Commissioners, we're going to move on to item.
Okay, sure, yeah. So,
Well, you know, hey, Doug, can you come back up? Let's move on to item Q, which is the motion for rehearing. Is Doug doing it or is Brad doing it? Or y'all both doing it? Okay. Commissioners, let's move on to item Q, which is discussion, possible action on commission and department procedures for reviewing and acting on motions for rehearing. In our last meeting, we discussed the possibility, we discussed that some of the motions for rehearing that we receive here do not technically meet the requirements that are laid out in the Administrative Procedures Act. And we've asked the general counsel to bring forth a document that we could consider of how we want to address the motion for rehearing. I met with Brad yesterday. They have a plan that they would like to talk to us about. And he's going to go into the whole issue about why this is probably a good time to do it from a liability standpoint, from the commission, and kind of speeding up, and especially as we anticipate with additional programs coming in, that there may be additional motion for rehearing coming in, so we need to start streamlining that down. So, Brad, I'm going to turn it over to you if you don't mind.
Thank you, Mr. Chairman, Commissioners, Brad Bowman, General Counsel. As the chairman was saying, this discussion was kind of sparked from a particular motion for rehearing at your last meeting. And the gist of that motion for rehearing, it just said, essentially, I want a rehearing. It did not make any allegation of error or any argument, really, for the agency to consider. But our policy has been, and our direction from the commission in the past has been to bring all of those, any kind of writing that we get that's attempting to be a motion for hearing, we bring all of those to the commission. However, Doug pointed out at that meeting that did not meet the legal requirements to be a motion for rehearing. And that kind of sparked this discussion. Should that be something that should come before the commission for consideration? There is we have a legal concern about that, as well as just, is that the best process? And so at the direction of the chairman, we did go back and kind of look at evaluate our process, and we came up with some recommendations to present to you today. If you like these, it could be something that you vote on today, or it could just be a discussion and a sort of a platform for further analyzing our process. And the goal here is to streamline the process as much as we can, and to, as Doug will go into, if there is a way to resolve an issue or to assist a respondent in some cases at an earlier stage of things, rather than waiting to bring that matter to the commission, if there's not really a legal issue for the commission to decide, then that would also be an opportunity for us at the staff level to kind of handle those in a more streamlined way. So that's part of the recommendations here today. So, and with that, I'm going to turn it over to Doug to kind of go through the specifics of our recommendations for you.
Thank you, Brad. Doug Jennings, Assistant General Counsel. As Brad alluded to, we've had some in-house discussion about the motion for rehearing process, and we've really we've provided you with the memo showing our research, but we've really come up with 3 recommendations that I think together will take care of some concerns about liability, but also help the department help the department and commission better serve our licensees and customers. And so our 3 recommendations are, first, kind of the one that you've heard me beat the drum for the last year or so, emphasize the statutory requirements for a motion for rehearing, and then 2 additional steps. One would be granting the executive director the ability to grant motions for rehearing in default cases where we discover a clear error has been committed. And
that would be with the assistance of general counsel?
Yes, that's correct. And thirdly, to grant the executive director the ability to probate license revocations or suspensions when appropriate. I'll speak to the first point. You've heard me say, and I think I said it again today, whenever I bring a motion before you, I like to identify whether or not I believe that the motion complies with Section 2001.146G of the Administrative Procedure Act. And of course, I usually don't say that whole thing because it takes too long. But in essence, that statute tells us what a motion for rehearing must contain. And knowing the purpose of a motion for rehearing is vital when reading that statute. The purpose of a motion for rehearing is to it gives the respondent one last chance to identify an error, if any has been committed in the process, in TDLR's process. But additionally, it gives you, gives GC, the opportunity to identify an error so we can fix it now rather than worrying about the case being taken up on judicial review or appeal. And so that's the purpose of the motion for rehearing process. It is not helpful or statutorily sufficient when we get a motion for rehearing that says, I want a rehearing, or I'm confused. While I certainly sympathize with a respondent who has those feelings, that is not legally sufficient. It doesn't put the department, doesn't put the commission on notice of any error, and also it could potentially expose the commission to liability or the department to liability. And it's difficult to make a clear statement about that because there's no case law on point. This section that I'm referring to is only, I think, 2 or 3, maybe 4 years old. There's not a lot of case law on it. But the concern is, and as you know, in order to appeal or take a case up on judicial review, a respondent has to exhaust their administrative remedies within TDLR. And what that means is, let's say it's a default. They've gone through the default process. They file a motion for rehearing. That is their in-house appeal. If they don't file a motion for rehearing and they try to appeal the case or take it to district court, the judge will just dismiss the case because the person did not exhaust their administrative remedies. And one of our concerns is if a respondent files a motion for rehearing that simply says, I want a rehearing, and we bring that to you to rule on, it's likely that the respondent, when taking the case up for judicial review, will say, no, I did exhaust my administrative remedies. I filed a motion for rehearing. The commission evaluated it and ultimately denied it. And so we believe that that would expose us to some unnecessary litigation. We should, so it's our belief that not only do we need to comply with the Administrative Procedure Act just as a good general principle, there are also additional concerns about potential liability. And so our proposal is not just to, with cold calculating gaze, identify half the motions for rehearing that use magic words and bring those before you and throw the rest in the trash can. That's not the idea at all. What we really want to do is cull the motions for rehearing that don't state any allegation of error whatsoever. We want to construe them broadly. There are some examples in your memo of some very verbose but very confusing motions for rehearing that don't seem to say a lot. But if you look at them a few times and interpret them generously, they seem to allege some sort of error. Yes?
Did we receive that memo?
I believe it was included with your commission materials.
Yeah, it's a part of the report, right?
Oh, it's in the...
Yeah, in his reporting section. I don't know. I just remember reading it. I can't get it to you now.
Well, I'm sorry. I was just going to say, attached to the memo were a few examples, a couple of examples of very clear motions for rehearing, a couple of examples of motions for rehearing that clearly do not meet the statutory standards, and some that are in between. And our proposal is to bring you the ones that clearly state error and the ones that are in between, and not to bring before you ones that just clearly do not state any allegation of error.
Sure. I thought there were good examples that that I saw and that I read last night, so I appreciate that. In the case that the executive director is not available, what's the process?
Before you continue,
sorry.
A lot of the commissioners don't have that. It's not in our general counsel. It's not a part of the item Q. So I don't know what happened to it, but if we could get a copy of that memo to us right quick, can we get that printed out?
We'll get that right now.
Okay, thank you. So, that's fine. I thought it was in here, and I don't know how you got it, but I did.
Special, let me see. I know they provided the examples of the different scenarios.
Yeah, I saw a copy of it yesterday, when Brad and I were visiting. So I know what it looks like and I know what they're referring to, but the other commissioners do not. So I'd much rather they have a copy of it.
Sure.
But as we proceed, now.
Mr. Chairman, did you want to proceed now, or did you want to wait until we have copies of it?
No, let's go and keep going. I think we're fine. Once they get it, they'll understand what they're talking about, because they can flip right over to the back and start seeing the.
And honestly, I'm doing my best to include all of the information that was in your memo.
And you have. I can tell you, I've seen the memo.
Omitting a few footnotes with citations.
You're fine.
One of the difficulties that we have had that kind of brought this discussion is that, as Brad mentioned, any kind of correspondence we receive from a respondent during the motion for rehearing filing period, we bring before you, just as a matter of policy. And oftentimes we will get emails from respondents who say, I just want this to go away, I'd like to settle this case, who aren't wanting to contest the case, who just want to dispose of it. And right now that's been difficult for us because we have to treat that, we've been treating those as motions for rehearing, and if they're legally insufficient, I'm going to bring them to you and recommend denial. And that may not be the best way to handle that licensee's concerns. They may want to dispose of the case. And so we believe that implementing this policy of taking to the commission only those motions for rehearing that actually allege error will help us be more responsive to these other types of correspondence that we get, where someone wants a probated revocation or someone is asking for to settle the case. That will give us another avenue internally where we can really help those respondents a little more. We can be a little more active in responding to them as opposed to what we're doing now. And so, as part of that, we have two additional recommendations I mentioned. One would be to grant the executive director the ability to grant motions for rehearing only on default cases when a clear error has been found. And in the last, I believe, 12 or 13 months, we have found clear error in our process 3 times and recommended granting motion for rehearing. Just to give a little example, I remember several months ago, typically I prepare these memos, your memos and our recommendations, a month or more before these commission meetings. And I had already determined that an error had been made in one of these motion for rehearing cases, and the respondent had driven 2+ hours, showed up ready to fight this, and my first recommendation to you was I recommend granting. We found a clear error in our policy, and the respondent was a bit stunned. And I think if we had had an alternative policy where we could have disposed of that case internally when we found the error, could have saved that respondent a lot of stress, could have saved travel time. It really could have been more responsive and gotten the enforcement process restarted in a different and more timely manner. And so our recommendation there is very limited. It would only apply to default cases. It would only apply to cases where the executive director and general counsel agree that a clear error of law or process has been committed. And keep in mind, these things are very rare. We don't have a lot of errors going on in our process, but when we do identify one, we just think it would be better to be able to deal with that internally rather than having to take it to you and waiting for a ruling from the commission before starting the process again. We could just be more responsive and more timely and keep respondents in the loop.
Which I think with the anticipation, again, as I mentioned earlier, with the number of cases that may start coming through because of the programs that we received, we've got to get into some type of a flow and a process by which we get these in and out. And I think that's the reason for this. And these default orders, Commissioners, I might remind you that default orders are signed by the executive directors because we gave them to them a while back when Bill was around. So we don't see the default cases until it's a motion for rehearing. Mm-hmm. And if there's an error for it, it should be able to be remanded back immediately once it hits GC, because the default order comes to the executive director. He just signs it and sends it on, and when they file for a motion for rehearing, that's when it's identified through GC that there was an error, and it just simply goes back. And by pointing it out to the executive director, who of course is not looking for the details, he's simply signing, it makes sense that he should be able to say, okay, well, let's start back over again. Which I think makes a lot of sense. I would also point out, what you talked about earlier, in an error and identifying that, it's basically, if they can say finding of fact, conclusions of law, that works great. Mm-hmm. But if in the verbiage of their memo, or their email or letter, or whatever it may be, they're saying ABC, which in reference is referencing a finding of fact, that also is sufficient.
That's correct.
To be able to say, they don't actually have to say finding of fact 12.
Correct, Mr. Chairman, and we would not be, and we are not currently, and would not be overly technical with those kinds of requirements. We understand that many respondents are not represented by counsel, and we would not expect, legalese or any magic words to be in a motion for rehearing. It's really the substance. Are they saying something to put us on notice that there's some kind of error, some kind of problem in the process?
Because if they say, I believe I am trustworthy because this was a one-time issue and I want a motion for rehearing, I think that type of verbiage is enough to trigger a possible motion for rehearing.
Well, Chairman, in my opinion, a person stating that they won't commit the offense again and is trustworthy, I don't believe would be sufficient,
Okay.
because they would have to identify a particular error in the process.
Got it.
But it would also depend. It would depend on the case, right? If the ALJ had made a specific finding somehow that, that dealt with honest, trustworthiness, and integrity, it would be a kind of a game time decision to see how that lined up with the ruling. But I just want to, I kind of want to reiterate.
Before you do that, Doug, I mean, for the delegation, I mean, in the event that the executive director is not available, what was the thought process, there, and to make sure the flow
apologies.
continues to go?
I believe our process would be, if the executive director is not available, I think it would just be normal chain of command.
Deputy Executive Director.
Okay, all
Yeah.
right.
And you might just mention what those timelines are, the days, because, well, I understand what you're saying. I think there's still enough time in there that we can wait for the executive director to come back.
Yes,
In most
there's a
instances.
100-day time period between
Okay, yep.
between the date an order is signed and when the commission has to act on it, or executive director.
And so when the PFD is adopted, they have 25 days to file a motion for rehearing.
That's correct.
But in the circumstances that you talked about earlier about, somebody saying, look, I am trustworthy. A lot of times they're just taking a shot at mitigating some of the findings, or the fine is what coming to us. Is there a different avenue that they can approach if it's that contingent versus the disputing of an error, that they're just looking for some leniency or some, does that make sense?
Well, absolutely, and I think that is what this process can actually help with.
So that,
I think if we got just a general email from someone who said, I want to get rid of this case, I'm trustworthy, it's not going to happen again. If I treated that as a motion for rehearing, I would bring it to you and I would say this is legally insufficient. And I would recommend that you deny that. And that would be the end of the story for that respondent.
Yeah, I have it.
However,
Yeah, go ahead. That's
if
fine.
we apply the statutory criteria, and I do treat that as something that is not a motion for rehearing, I could potentially contact enforcement and say, we have a respondent who says he wants to settle, won't do it again, and potentially they could enter into an agreed order, or they could just say, no, let's say the administrative penalty that we assessed was $3,000. He says, I won't do this again, I'd really like to settle. We could kick that back to enforcement for them to decide whether or not settling for a lower amount or the full amount or something like that is appropriate. And so there are kind of additional steps that we can take to be more responsive to our licensees that will arise as a result of us applying these kind of tighter controls on what constitutes a motion for rehearing.
but I guess the contention is as commissioners, are we comfortable with that, kicking it back down to enforcement? I mean, because the subjectivity of that is pretty huge, right? And so sometimes it's you're in the weeds. It's sometimes good to have just, I'm just advocating what we're giving up is that ability to be the outside person who hasn't seen the case, and that the subjectivity of leniencies falls on us. That's there's some merits on either side. Efficiency is important, but at the cost of the people being represented and being pushed back against an agency is a big deal.
I share Rick's concerns there. We're the last. We're the last court of safety for the little guy. And how many times have we granted a motion for rehearing based upon something that was done incorrectly, or at least by our lights, by the agency? Do you have some number?
In the last year, you have granted 4 motions for rehearing, 3 on our recommendation, and 1 against.
And so, I mean, 1 doesn't seem like a lot except to that person, right? I mean, they're going up against the machinery of the state of Texas.
May I?
Yes,
we still would have brought that motion for rehearing to you. And so I completely understand your concerns. And that's one of the things that we thought about during this process is we want to make sure that we are bringing legitimate disputes to you, allegations of error. If someone says, I didn't receive notice, that this is unfair, we would bring that to you, either now or under this updated process. What we wouldn't be bringing to you in the future would be MFRs that say, I'm not going to do it again, I'm a good person, I understand this is a mistake.
Or just one that says, I request motion for rehearing.
Right. You will still be getting, and it is our intention to read these very broadly and forgivingly so that you would be able to judge, to weigh in on legitimate disputes. Really, we just want to make sure that we are not bringing before you how shall I say, just specious arguments. You know, and one of the things that we always do, and one of the things that our office always does, is whenever we receive a motion for rehearing that alleges error at all, scour the case files, look through all of the documents, and make our recommendation. And so my contention would be you have an excellent first line of defense. I understand your concern. I absolutely do. But I think that we will be bringing before you any legitimate dispute. And so you have the position.
So internally in your office, either the prosecutor's office or enforcement, is there, for lack of a better term, a devil's advocate that can argue the opposite side in some of these? I only say that because, like Rick, I mean, we're here to represent the little guy.
Mm-hmm.
You know, that's why we have no ties to the industries that we regulate. Because if I were a Texan and I was an air conditioning guy and some allegation was made against me, I'd want to know that there was somebody impartial that I could finally get to. And I know this is further along because these are motions for rehearing, and oftentimes they say they didn't get the letter and that sort of thing. But still, you know, you have to have some recourse. This is a free and open society, and you've got to be able to tell the boogeyman, which is state government, you know, I'm being mistreated here. And we're the last line of defense in that argument.
Commissioner
So
Butler.
I'm a little apprehensive in some way, and only because you're taking some measure of power from us, in a way.
Absolutely. And I can definitely understand where you're coming from. Brian Francis, one of the examples today, the Carmona case, she was notified on June 14th about the July 20th meeting. And what the commission arrived at, we would have arrived at under this process on June 14th. She would not have had to come up here with an attorney. She would not have had to pay the attorney. She would have had quicker justice in those moments. We are not trying to move those away. And in fact, you know, the process that I've undertaken now doing the defaults, and enforcement can attest to this, when I get a default order and it speaks to revocation, I've asked and I've required the enforcement division to call again. Now, this person had an NOAV, they had a default order going to them, it's in front of me to sign, and I can sign it in 10 seconds, and I have them reach out, call again and say, your license is on the line for X. Please give it a shot. And so I definitely can appreciate where you're coming from, and I've folded that into the default process. I am making sure that we are reaching out to those individuals. This will give us an opportunity for those who, as Doug said, does not meet the standard of a motion for rehearing to not wait 45 days to find out it doesn't. But it does meet the possibility of a settlement, and we can start those negotiations sooner.
Yeah, and I like that. I put myself in the shoes of the little guy. You know, I was an electrician's helper, worked my way through college, and I could just imagine if I got called before the state of Texas, you know, as a 26-year-old young man going, holy smokes, what do you want? Just, I'll write a check, just make it go away, when that may not necessarily have been the right outcome. And so I guess a lot of it is in the making of the sausage.
Absolutely.
And so, you know, just be careful.
And I think one of the things we have to understand is that, you know, the motion for rehearings, the first time that they come anywhere goes to GC.
Mm-hmm.
And GC will go through their process to find out if they meet the requirements and everything. I think that's a responsibility. Again, if you remember in our last meeting, someone gave us, we had a motion for rehearing, and it simply stated, I want a motion for rehearing. And that was about it. It legally did not meet the requirements of a motion for rehearing. And so the other aspect of that is that it will begin to start tightening up the liability and keep that from happening in the department.
Mr. Chairman. Oh, sorry.
The other thing that I was going to mention
So long, Brad.
is, the other thing I was going to mention is in the Carmona case we just saw. She had already been in a payment plan. They would have already said, okay, let's go ahead and suspend the revocation, which meant that she didn't have to be here with an attorney present.
That's right. And that's,
You know,
yeah,
because of
yeah.
course, you know, we all want to pay attorneys. And so there wouldn't be that additional expense.
Sure.
I think that if we can give, in my opinion, if we can give GC a very narrow gate by which to go through, I think this would help out. I understand your concerns. I think that we're here and that the citizens or our license holders are afforded the opportunity to come before this commission, and we need to follow that. Now, I've talked to Brad. One of the things that we talked about was, you know, from the time that the PFD is issued, they have 25 days. If they go to day 20 before they finally issue a motion for hearing, I mean, they're really pushing the envelope. 24, day 24, they're pushing the envelope. If they submit that request right away, it's difficult, and I don't know if we can get to that point because of the way our system works. You know, but if we could have a cursory look at that and find right away that it doesn't, if they just simply say, I'm requesting motion for rehearing, and that's it, that we would be able to reach out to that person and say, you don't meet the qualifications, look at the letter we gave you, it gives you specific details of what you need to do, follow that, and leave it at that, and let them go back to do it themselves also. So that we're just not dismissing people. I mean, and there's a process, but at the same time, I also know that we cannot have anybody dedicated to looking at each one of the motions for rehearing that come in and evaluate them the moment they walk through the door to see if they meet the requirements and qualify for a motion for rehearing. So there's kind of, we have to weigh this to figure out what, you know, and balance this out accordingly. Because I don't want to add additional staff.
Right.
It's not what I'm asking to do. But I also know, as an example, if Doug were the one reviewing the motion for rehearing, he's got other things to do. I've got him working on a couple other things, so it's you know, it's difficult to turn around and say, you know, just dedicate to that. But
And that's a good argument, because this lady didn't need to be here today for us to say,
With the
yes,
attorney.
just continue with what you're doing. I mean, that's a waste of time.
Yeah, Mr. Chairman, I mean, it's definitely, I think, a smart way to go. I mean, we talk about the efficiency, the cost savings, and so forth, and I would submit to you that being proactive, right, and making those phone calls, that just ups the level of the customer service that's highlighted in the strategic plan. So, I mean, I'm good. Anything else?
Mr. Chairman, the only question I have is that I agree with the other commissioner and what you were saying about oversight. I don't like being on a commission where you're still not the one that's overseeing the commission and of the state of Texas. With all due respect to legal counsel and the executive director, I think we still should have oversight of at least some type of correspondence to where we can make sure that all of these are not going before our commission. At least that way it can be placed in front of us where we can look at these.
I'm glad you mentioned that. Brad's got something on that.
And, yeah, Mr. Chairman, and Dr. Callis, that's a good point. One of the recommendations here would be to have a regular report to the commission as part of your the regular reports that you get on default orders, agreed orders, et cetera, so you would have that monitoring function. You can see all of the writings that we got in and how that was disposed of. Did it come to the commission as a motion for rehearing?
Right.
Was it settled? Whatever the disposition of it. Did we send them a letter saying you didn't meet the requirements? You know, whatever the outcome was. So to have that monitoring and oversight function.
With that being said, Mr. Chairman, I'm for all for this proposal with that caveat that there's still oversight by this commission.
And Mr. Chairman, the comment that you made about following up with respondents, we can fold that into our process if that's the will of the commission. Yep. I think the example was if there's still sort of time on that 25-day clock, we get some kind of correspondence in, it clearly doesn't meet the requirements, can we follow up with that respondent? We can't give them legal advice, but we can tell them, just like we tell them at the outset, we give them very detailed information on how to go about filing a motion for rehearing, what you need to do, what you need to put in your motion for rehearing.
Absolutely. You got to be crashing the boards that way. You know, you got to step up the game in that perspective.
And maybe in the letter that you send them, you know, if we boldface, these are the requirements, please read carefully the following items that need to be included. Some identifying markers in that letter that let them know, hey, this is what you've got to have. You know, shaded in a gray area, something to the effect that it sticks out to them. While I want them to know, the other side of that is that I don't want it to take up a lot of staff time in that because you got other things to do. Well, I think this will streamline. We got to figure out a different way to boldface that, to bring it out to the people whenever they get that letter, that they read it carefully and say, okay, this is what I need to do. Read carefully, right here, arrows, neon lights, whatever. pointing to that area of the letter, telling them what they need to do. So you understand what I'm saying?
Yes, sir.
And if it's still, if you still get one on a cursory look that you know does not, then maybe, like I said, we can send it to them right quick. But I think that cursory look at the very beginning might help. But I think if we tell them up front and do something, that may alleviate some of it also.
Mr. Chairman, Brian Francis, the other thing I'll add, and hopefully this gives some comfort, is it's not cemented. It's not in stone. If we go through this process to the next meeting and the next meeting and we feel like it's not working, too many went left and not enough of them went this direction, we can go right back to where we were. I mean, there is nothing that's going to be concrete about the process. We can evaluate, and there may be a part of it that says, you know what, I want this group, but keep that, but let's move forward with that.
I think we got, and this agency has done it very well. And I need to commend y'all for coming to us and saying we made mistakes here, and we don't want to get to a point where things don't percolate to us because you want to CYA.
Absolutely.
And if y'all did something wrong, let us know. And the more that happens, probably the better and more comfort we'll have when things like this are brought before us. Because if you can come to us and say we messed up here, then we can address the issue. That's the only feedback loop that we have, is unless we hear from a taxpayer, you know, something went wrong here, and then we come to y'all. We don't want to have to hear it from them. We'd much rather hear it from y'all. We messed up, and this is how, and this is why, and this is what we're going to do to make it right. Because the way I look at it, we're kind of taking a little bit of that feedback loop out of it. Maybe I don't have my head around this yet because I'm just now looking at it for the first time, and so a little uncomfortable with it. Willing to give you that power so that this lady didn't have to come here today and spend all that money on the attorney for something that's just kind of a no-brainer.
I mean, he
in my
literally
mind.
just introduced himself.
Yeah, and so he made his payment on his vehicle today, but I mean, that's the only purpose that it served.
Well, hopefully it won't be towed.
Anything else, Brad?
Oh,
Did we
Mr.
forget
Chairman,
anything?
just on Commissioner Butler's point about kind of fessing up if we have made an error, I think there'd be two ways that would still happen, like we do now. If there's a motion for a hearing that comes to you and we see an error, we'll acknowledge that and make that recommendation to you that you grant. And if it's one that we handle internally, that would go on the report that would identify the error, and we could even identify what that error was an improper notice, or whatever might have.
I'd be very comfortable with that because that's how we learn.
Good with that?
If y'all can acknowledge your errors, and that in the future, that's one way of saying, this is what we did in the past that wasn't right. Let's kind of make it a little better. And that, as an organization, that's kind of how we develop this body of knowledge as to what works and what doesn't, the best practices. I think I'm done.
Any other questions for Brad or Doug? Anything else for us?
No, sir, this is just a discussion item, and
Well, it's also an action item.
it is potentially an action item.
Commissioners, are you comfortable with adopting these new procedures for motions for hearing?
So moved.
Second.
We have a motion and a second to adopt the new procedures for motion for hearing. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you, sir.
Thanks, appreciate it. I think this will help out our meetings, especially in light of the future, so I think this will be good.
Doug, great job.
Let's go
Chairman,
back
thank you.
to item I, approval of the LAR.
Mr. Chairman, Brian Francis, commission members, I want to
You have a
go
copy
over.
of that that's just been handed to you also.
I want to go over the agency's proposed legislative appropriations request. As indicated in the cover email that I provided to you a few days ago, we believe that it provides a very conservative and fiscally responsible approach to what the agency needs. We've had an opportunity to meet with the governor's staff and to review these elements as well. It centers around two things. We need to have a single licensing system. One single platform that unifies the 9 disparate systems that we currently have. The challenges that we're experiencing in this multi-system world is that in licensing, we have staff that are cross-trained on different licensing systems. We have a very, very expensive pay-to-play licensing system that we inherited from the transfer of the health programs. Minor changes to the web page, minor changes to the system are costly and they're delayed. We also have the cost and the delay in between the systems as it relates to customer service, receiving the same data in the same way when a customer calls in, having better communication between a single licensing system and our enforcement database that we call legal files will allow us to be more efficient. And then finally, having the ability to have greater protection of the personal identifiable information in our systems, as we're getting the personal identifiable information as well as the PHI, which is the health-related information. Anytime you have more than one system, you have the potential for some exposure. And so having a single platform is our first exceptional item. We've gone through, we're the very first agency to go through the application development and decision framework. It was developed by the Department of Information Resources, and simply put, it's not just the agency saying, here's what we want in this big, shiny, new toy. It is a very deliberative process that includes experts from other agencies providing input. Carla had her staff, Jody, we had our Office of Innovation involved in navigating us through that process. So the ADDF identified what could be the optimum licensing system for the agency. We've included that into this process. We want to make sure that there is money up front to allow for a very comprehensive information and requirements gathering process early on, so that we're not just building a system on the fly, but as we talked to Commissioner Figueroa, it would be a component module-based system that will give us flexibility as the agency may increase responsibilities, but more importantly, having consistency across the functional items, the examination elements, the education elements, the licensing elements, the inspection elements. So we're excited about the prospect of moving forward with this. We feel very comfortable in making a positive case to the legislature. In our first biennium, our plan is to have 77% of the individual and business licensees transferred into this system. And then the remaining 23% would have to come in the next biennium. Carla's already said that once we figure this out in the first biennium, we'll be aggressive and move as many as possible. But we've identified cosmetology and barber and massage and electricians and a few other programs that we think if we can get them in, it's going to set the standard and the model and the pathway by which we can fold the other programs into the system. The Department of Information Resource has been involved in the process. I'll have Carla talk about the QAT that's on the tail end of it.
Good morning. Carla James. So the Quality Assurance Team is a team comprised of representatives from the Legislative Budget Board, the State Auditor's Office, the Comptroller of Public Accounts, and Department of Information Resources. And every state agency who wants to move forward with an IT project that's anticipated to exceed $1 million has to go through a process through this team and submit information about our business needs, what the plan is, anything else that we think is important to this project, to that team, and they have to approve it before we even start. So there's another process to go through to determine and ensure that we're on the right path before we get started. That cannot happen until after the funding has been approved. So Jody Ashlock, our Chief Information Officer, and her team, once we get about halfway through session, if it looks like we're going to be successful with this request, she and her team will start putting together that information so that right after session's over and the governor has signed the bill, she will submit that to the QAT team so that we can get started on September 1st. We are not going to slow down. Once the funding has been approved, it's pedal to the floor.
Mr. Chairman and members, exceptional item number 2 is to combat human trafficking. This exceptional item really ties into TLR's new elevated role. When you look at a report that was published by the Polaris Group, which is a thought leader in the area of human trafficking and prevention, one of the areas that it identified is that regulatory agencies have a better opportunity to get into the door into those illicit massage businesses. We have a regulatory reason to go inspect and to get into there. And what we've discovered in the short time with the massage program being at TDLR since November is that there is a lot of collaboration with the LEOs, the law enforcement organizations, whether it be the local police department, whether it's the county. We're also having involvement with the Attorney General's office. The information and data we are able to provide to them to assist them in their efforts, and the information they're able to provide to us to assist us in our efforts have been tremendous, but they are going to be big. The massage program, as you know from the predecessor agency, did not have a regular inspection component. Now we are going to have that, and that is going to identify a lot of opportunities. to see human trafficking. We're not convicting it, we're just seeing those signs of it and being a referral agency. I remember when the program, before it arrived here, the chairman had forwarded me a newspaper article, and I won't go into it, but there were a significant amount of plumbing issues related to the evidence that there was sexual activity taking place in that facility. We're going to see that. The other part that gets lost in the conversation for human trafficking is the labor side of it. When you look at TDLR's world, the massage side of it may have the sexual component to it, but the manicurists, the construction side, whether it's AC or electricians, it's going to have the labor component to it, and we're going to be just as involved in being able to identify that. The positions that we're asking for are 4 positions, 2 inspectors, 1 program specialist position, and 1 management analyst position.
Brian, could you talk a little bit about the labor aspect of this?
Yes, sir.
Because this is something that's kind of lost sometimes, and kind of, you know, how does that manifest in the real world, the labor aspect of it, if you will?
Well, in our world, where we will see it most will be on the proliferation of construction sites. You're going to have camps where folks are housed, and they're saying, hey, you can come over and work for $12. When they get there, they're getting $5 because $4 is being siphoned off for the lodging, $2 is being siphoned off for food, and they're not getting the benefits that they thought they were going to be receiving. We also will see it in some of the manicurist locations where there's bedding in the back room, where people have living quarters, where they're being bused there in vans. That type of labor trafficking is huge. Texas sits around number 2 and 3. We alternate in terms of states with the highest level of human trafficking, labor, and sex. Houston sits around number 2 for cities, behind New York and Los Angeles. It kind of varies between that. But the labor part gets missed. It gets missed in that conversation. I'll be testifying next week in Houston at a hearing dealing with just occupational licensing and the construction side of it. This is a part of that conversation that gets lost. And we're going to be able to elevate that conversation to be a player in it. We have identified positions that are necessary to provide training in-house, to create consistency and a little bit of awareness, to provide training to different law enforcement agencies, what we can do to provide them information, the data that we have to assist them, and providing training to our licensees. Right now, with House Bill 2552, we have the requirement that the sign is placed in the cosmetology establishment. There's more we can do. There's more we can do to provide information to that electrician or that contractor to say, if you see this on a site, if this is in proximity, here's all you have to do. And I can't remember who asked me the phone number yesterday, but it's 1-888-3737-888. That's all you have to do when you see it. 1-888-3737-888. I know some of our staff is a little bit uneasy, and it's like, oh, we're going to be, pulling people out of human trafficking. No, we're just going to say, this feels off. This is odd. And when you do 1-888-3737-888, that number will contact the local folks that are responsible for addressing human trafficking, and it'll get them there. That's what our eyes are going to be able to do. And training people to get comfortable that you don't have to engage, you don't have to tackle anybody, you don't have to beat anybody in the face. You just dial a number, and you've done your thing. So I'm excited about the prospect of that. Obviously, this initiative is very near and dear to the governor's heart. It's very near and dear to the Attorney General's heart. We sit on multiple task force already. Jennifer Harless is our coordinator, but we are finding out that she's not incredible in terms of the Incredibles and being able to stretch her body in all the directions that she's already being pulled in. And so we need to have a task group that's going to allow us to be a little bit more nimble and responsive to those issues. Commissioners, the last 2 exceptional items, they're cousins. You may remember these because they were there last time. You may recall that the agency was asked to reduce its budget by 4%, and we did. This is simply saying, in the area of licensing, please give us back the 3 folks. Give us back the 2 licensing people, and we'll be able to process 20,000 more applications. Give us back the 1 customer service rep, and we can do 15,400 phone calls. It's also asking for 2 investigators and 2 inspectors back on the enforcement side of things. What we're calling this is just bringing our baseline needs back up to where they should have been prior to it. You may have followed some of the information out there regarding the biennial revenue estimate. Things are not as bleak for Texas financially. Doesn't mean we need to run crazy and ask for the shop, and we didn't. 4 years ago, we had 11 exceptional items. Last year we had 5. This year we have 4. And the dollar amounts that we're asking for are less than they were last year. We're at $5.4 million. This year we're around $3.9 million. So we're not asking for the farm. We're just asking for the tools and the equipment to farm what we have already and to farm it more efficiently. I'm going to turn it over to Carla, but before I do, I want to give great praise to Carla and Tony Couvion. Their efforts have been just incredible in helping us build this process in this LAR. This is the first one that I've not had my hands directly involved in, and it was comfortable. Carla and Tony did a great job. I want to give praise and acknowledgement to Jerry Daniels and to Mary Alice Till and Deborah Jackson in Financial Services, because they've done some monumental work, but once the commission makes its decision today, their work really increases because they have to get the stuff in by next Friday, and that's not an easy task. And I also want to thank Jeff Kopis, Anna Clark, and Rhonda Reinhardt for the editing and the writing of the information that you've seen in the administrator statement. There's a lot that goes into building an LAR, and so I'm very appreciative, and I'll turn to Carla to close out for anything you may have.
Thanks, Brian. To put it into perspective, Brian loves the strategic plan. I mean, he really gets excited about it. You've seen that. So the LAR is my gig, and you don't see me getting really excited about it, but you don't generally want numbers people to be overly excited. That rings of Enron-esque type stuff. I think we've got a great plan put together. Well, I was a securities regulator for 10 years. Still kind of mad about that. But as Brian said, we're in a much better picture than the state thought we would be in, and I think that played a major factor in the requests that we've got. Want to remind everybody who's listening, this agency does not request new money. We request the authority to spend the money that we bring in. Rather than putting it back in the general fund, we are simply requesting the authority to use that money rather than putting it back in the general fund. I am excited about this LAR. I used to count the years to retirement on how many LARs I had to do. But this was a different situation. The team put together a great amount of information. It was very collaborative, sometimes painfully so. And this, without doubt, is the best LAR that I've put together in my career. So I'm very excited about taking this forward to the legislature. We've got a really, really good message to bring, and I'm very hopeful that we find some support on our licensing system. I think that's going to be a phenomenal change for our licensees and our customers to see what it's not a little bit amount of money, but $2 million in the grand scope of things of an $80 billion budget per year is a little bit amount of money, and I'm excited about the potential of us getting the authority and making a significant difference.
Yep.
Oh, and we want to thank Doug Van Pelt on the cover that I haven't seen yet, but I'm sure it's awesome.
It's pretty.
Yeah, I was going to say, if you haven't seen the cover of the new Barber and the Cosmo books, I'll tell you.
It looks real.
We have upped our game, boy, I can tell you that.
Looks like a magazine cover, doesn't it?
It does. It looks great.
Mr. Chairman, we're available to answer any questions that the commission may have.
Any questions for Brian or Carla? You have before you the LAR. I think that the total projected request is just over $71 million over a biennium, which would be for 2020 and 2021, fiscal year 2020, 2021. You know, whenever I got this, I looked, I was like, oh my gosh, that's way out there, but not that far away.
It's not.
So, any questions?
Yeah, this same version that I saw the other day, or is there any edits to it?
There are no changes.
There's no edits, but we need to offer one edit. Whenever you run something by your attorneys, they read it thoroughly. And Brad found a very good change where we talk about the ratio between one employee for every 1,742 licensees. We say that it's strengthened. We're going to just simply need to change it to 1,742 licensees for every one employee, and now our strength statement will be accurate. So thank you, Brian, for pointing that out. I just read it last night.
So it's like, the way it read was one employee for every 1,700.
Yeah, and it was like, and we got better. It was wrong.
Okay, so that'll change.
Okay. Thanks.
Any other questions? If not, motion would be in order to approve the LAR request.
So moved.
Second.
We have motion and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. I would also
Thank you very much.
Make a note that the LAR was also submitted to the Audit Finance Group, which was consisted of the presiding officer, Vice Chair Butler, but also Commissioner Figueroa and Commissioner Collier. So, real quickly, we're going to take a real quick break. Before I do want to make a couple of quick item notes. For those that haven't noticed, in the back, we have a familiar face that decided to come back to us after about 4 months. Charles is back.
Yeah.
So he's retired and realized he didn't like it too much, so he came back. So
Like a bad penny, keeps popping back up.
exactly. So I'm assuming, maybe by January, February, we'll see Kay back. So, we kind of seem to be moving in that direction. So also, commissioners, we mentioned to you about the executive director evaluation. You'll be getting an email from Sharon. She's tidying up the survey that we received. There was a couple of notation errors that we discovered at the beginning of the week. So they went back and asked for a correction. So she's waiting for that to come in. But once that happens, you'll get an email from her for the evaluation. Let me tell you, we set deadlines. She's going to send it out to you about August the 15th. I'm going to ask that you return it back to her August the 29th so that she can have the time to be able to process it, put it all together, send it back out to us before our September 14th meeting. So put those, you'll see the emails come across, but put those in your mind that August 15th, you'll get the evaluation, need it back by August 29th for our September 14th meeting, because she has to process it, put it all together, and she's going to email it back to us so we have an idea of what it all looks like prior to that. So other than that, let's take a real quick break, about a 10, 15-minute break, and we'll come back after that.
to
I'd like to call the meeting back to order. The chairman had to catch a flight, so you're stuck with me. And so I think I would like to move a few things around. We're going to lose Ms. Collier here soon as well, so let's talk about things that we do need to vote on. And so that would be the criminal conviction guidelines.
Those can go quick, and then we'll come right back to the rules for J, K, L, and M as well.
So we're talking about NOP?
Yes, sir. And then J, K, L, and M.
Okay, J, K, L, and M.
NOP?
NOP, J.
Let's get to work.
Let's do it. Okay.
Which one do you want first, Mr. Chairman? Letter J?
I will let you decide that because we're going to lose our quorum here really quick.
Absolutely. Do letter J, boilers?
Okay. Boilers, please.
That's okay.
I'm going to ask the staff to be as quickly as possible, so if you're next in line, don't wait for the B-Fran introduction from poetry. It's just going to be a straight up to the table.
On deck, right? Who's on deck?
On the deck.
Who's on deck?
Morning, Commissioners. I have 75% of the rules, and I'm hoping to persuade you to approve 100% of them. The first one is boilers rule amendments, 2 technical changes. There was a national standard change. We added the word bare tube. We changed lower than to greater than in 2 places. If you want to know more about boilers, I'll answer questions, but those are the changes. They're technical, they're uncontroversial. We had one comment suggesting that the bare tube be added in 3 more places. We agreed that it should be added in 2 more places, and we couldn't do it in this rule making because it hadn't been noticed for those other 2 places, so we're wrapping it into the next rule.
Okay.
So these were proposed on May 11th. The comment period closed June 11th. We're recommending that you adopt them without changes. And as I said, we'll wrap in that change that needs to be made in 2 more places. We'd like to ask that they be effective on September 1st, 2018.
Okay. Did we incorporate the Nebraska rule? Are you the only one that remembers that? Everybody kept referencing Nebraska rule, Charles? And then Charles contacted Nebraska and they found out there was no rule in Nebraska. Okay. All right, so.
These are compliant with the
These
Nebraska.
are compliant with Nebraska, okay, that's important.
Mr. Chairman, they've gone through the advisory board as well, so.
Wonderful.
They came to their field.
So the chair will entertain a motion.
So moved.
We have a motion and a second. All those in favor, please signify by saying aye.
Aye.
The ayes have it. Thank you so much. Next, mold assessors
Yes.
and remediation program.
The amendments to the mold rules, one of them is from House Bill 4007 from the last session. These are in 16 TAC Chapter 78. The legislature changed the the time period they have for providing the property owner with the before and after pictures after a mold remediation from 7 days to 10 days. So it gives them more time. The other changes from staff are to update and make clarifying and consistency changes to the records retention requirements and to amend the laboratory requirements to continue to require the mycologist or microbiologist to oversee a mold lab. That was always a requirement, and in the transfer it got a little muddled, so that's been restored to, that requirement's been restored, and we received 4 comments on the rules, but basically they were comments on things that were not proposed for changes. So since they weren't proposed to be changed, we couldn't proceed to change them in this rulemaking. We do, of course, take them under advisement for the next time. The HB 4007 change did not result in any comments. The comments about the qualifications for people, licensees in the program, those sorts of things. We hadn't made substantive changes to those. They're really just kind of clean up and clarifying changes. So that's why we're suggesting to adopt them without any changes. So our recommendation is to adopt them without any changes at this time, considering that we're taking under advisement the comments, and with an effective date of September 1st of 2018.
So moved.
We have a motion. Do we have a
Second.
second? Motion and second. All those in favor signify by saying aye.
Aye.
Aye. And the motion carries.
Mr. Chairman, if we could go to agenda item M so that Laura can stay at the table.
Yes, sir. Let's do it.
Mr. Chairman, this is Brad Bowman, General Counsel.
Yes,
I just
Brad.
wanted to interject something here before Laura does her presentation. I believe the Commission is already aware of this. We sent this information to you earlier this week, but there's a wrinkle on this rule, and that is that one of the interested parties has requested a public hearing. We got that on Wednesday, I believe. That's the Podiatry Association, through their attorney, requested that that hearing, and the Administrative Procedure Act requires that if an association of 25 or more members request a public hearing, we have to grant that. And so our recommendation would be, and we haven't had time to give any notice of that hearing, so we have to do that separately from the meeting today. So given all of that, the recommendation is to pass on the particular rule on which the hearing was requested, and that is 114.75. That's the rule that generated a lot of comment, and that would give all the interested parties an opportunity to attend that public hearing, make any further comments, give us any further information that they have on that, and give a full opportunity for the parties or any interested person to speak on that particular rule. So we would recommend that in your action here today, you can go ahead and take action on the remaining rules in that program, but to defer any action on that particular rule that could come back to you at a future meeting.
The chair will entertain a motion.
So moved.
Move to accept, with the exception of Rule 114.75.
And you may want to hear Laura's a brief presentation on the remaining rules. They're more technical in nature, but
Forgive me, Laura. I stepped on your feet there.
Well, they're big, so. The proposal, of course, was for Chapter 114 amendments to the orthotics and prosthetics program. There were a lot of changes, updates, consistency that have nothing to do with the section that's in dispute here. There was only one comment on all of those other changes, and this was a misguided comment basically on the Texas residency requirement, because that was a statutory change from HB 4007 that the Texas residency requirement went away. So the proposal, of course, included this 114.75 section, which is on scope of practice. This is something that the advisory board wanted to put forward. Since we do have the hearing request, we can't undo the fact that it was proposed, but we're recommending to just drop that section out. We'll do the public hearing and then go from there on that one. The rest of the changes are uncontroversial. As I said, we only had one comment on the residency. They were published on April 13th, and the comment period closed May 14th. The board had met on June 11th and is good with all these changes. And so we're recommending that you adopt the proposed rules with all of the changes, all of the sections except Section 114.75, and there are no other changes except for leaving out Section 114.75, and with an effective date of September 1st of 2018.
Thank you, Laura. We entertain a motion. We have a motion, and do we have a second?
Yes, second.
We have a motion and a second. All those in favor, say aye.
Aye.
Aye. The motion carries.
Thank you.
Moving on to item N, I think is where we're at. Criminal guidelines, criminal conviction guidelines for registered sanitarians.
Mr. Chairman, I think that we skipped L for vehicle booting in.
Correct. We need to go to vehicle booting, Mr. Chairman,
Okay.
for rules.
Trevor, gotta go.
Don't run too far off. Don't run too far off.
That, so.
Thank you, Elizabeth.
Good morning. Elizabeth Salinas, Strip Matter, General Counsel. Putting before you today a proposal to repeal the existing rules under the Texas Administrative Code for Chapter 89, which are the rules currently in existence for booting. This is pursuant to Senate Bill 1501 and Senate Bill 2065, which deregulated booting at the state level. So we are just repealing the rules in concert to be in line with that deregulation. The proposed rules were published in the Texas Register on May 4th. Comment period closed on June 4th, and we did not receive any comments in relation to the repeal. The Booting and Advisory Board met on June 18th. We discussed the proposed rules and the fact that there were no comments, and so we are now recommending adoption of the full repeal of Chapter 89.
Do we have a motion?
So moved.
We have a motion. Do we have a second? We have a motion and second. Please signify by saying aye.
Aye.
Aye. The motion carries. Thank you.
Elizabeth, do we have a recommended effective date?
Of September 1, 2018.
Thank you.
Thank you, Elizabeth. Now can we get to N?
Trevor Thielen with the Enforcement Division.
Mr. Thielen, thank you.
You are being asked to review, discuss, and take action to adopt the proposed sanitarians criminal conviction guidelines. These are what we use to identify the offenses that might lead to license revocation or application denial. These guidelines in the sanitarians program were initially drafted by enforcement. They were edited, improved, discussed by a Sanitation Advisory Committee work group. That committee's work group's recommendations went to the full Sanitarians Advisory Committee at their May 8th, 2018 meeting, where they recommended that you adopt them, and that's what we're asking you to do here today.
Are there any questions of Mr. Thielen?
No questions. So move that we adopt.
Okay, we have a motion. Do we have a second? We have a motion and second. Please signify by saying aye.
Aye.
The motion carries. Item O, discussion and possible action on criminal conviction guidelines for code enforcement officers.
It's going to sound very familiar. The Code Enforcement Officers Advisory Board work group convened to consider criminal conviction guidelines that were initially drafted by enforcement. They provided input. We edited them. We improved them with their recommendations. It went to the full Code Enforcement Officer Advisory Board at their May 10th, 2018 meeting, where they recommended that you adopt these guidelines, and that's what we're asking you to do today.
Any questions for Mr. Thielen? The chair will entertain a motion.
So moved.
We have a motion and a second. Please signify by saying aye.
Aye.
And the motion carries. Continuing on, driver's education, driver's training and traffic safety program.
Good morning, Commissioners. Ron Foster,
morning.
Senior Prosecutor in Enforcement Division. I will be presenting this matter. We will be asking you to approve the penalty matrix. That is the enforcement plan for the driver training and traffic safety program. The board did meet on February 12th, March 7th, and April 13th to consider and modify and ultimately approve and recommend these drafted penalty matrices to you for approval. On the board, we had Presiding Officer Ricardo Benavides, Francis Gomez, Carlos Reyna, Nina Saint. We also did have participation of the whole agency, including the Assistant GC Mark Gladney, and Education and Examination Michael Strawn. If you would consider these, let's see, I think you should have copies of them. We do have 4 separate matrices, but if you would consider those for approval.
The chair will entertain a motion.
So move to accept. Second.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
The motion carries.
Thank you.
Thank you, Mr. Ross. I think those are the only things that really require a vote at this time. I think we're ready to move on to staff reports. Brian, is that where we're at?
Yes, sir, that is exactly where we're at. And, Mr. Chairman, at this time, we do not have any staff reports. I was trying to put an eye on our new director of RPM, David Gonzalez, but he ran back upstairs. I think that was an intelligent and wise move on his part. Commissioner Collier, at this time.
Right. Yeah, and I think so. I do appreciate it. I do want to note that from the staff report standpoint, I definitely like the moves that Jody's making in the IT aspect. very, very strong there, so make sure you relay that message. Stood out on the code enforcement side, where some activity's been going on with meeting with folks who recently coming out of a TDCJ and so forth. Really like that kind of movement because it ties into labor licensing and so forth. So
Yeah, Christina's group is really taking the lead on.
Yeah, appreciate
on making
that.
sure
That's
those
very,
conversations
very
take
strong
place.
there. And that's what sticks out in my head, but I'll send some emails with further comments.
Thank you
but I
very much.
appreciate that.
I'll also add, in addition to the items that Jody's working on, if you look at the depth of projects that are being handled by our Enterprise Project Management Office, it's phenomenal. That list there's a lot that's happening underneath the hood,
Yeah,
and
very-
really grateful to staff's efforts.
Very, very impressed, so thank you.
Without any further items, I'd like to talk about future commission dates. Thank you, Ms. Collier.
Thanks.
We currently have September 14th as a confirmed commission date, September 14th. And I'd like the commission's feedback on a couple of suggested dates. October 19th or
September 14th is, you sure?
September. I have September 14th as confirmed. Do y'all have that? Okay, so we have that one as confirmed. September 14th. We have a couple of suggested dates, and I'm going to give you a second to kind of get your calendars up. One suggested date is October 19th with the following date of November 30th, both Fridays. Right now, does that seem like it's okay?
October 19th I can't make.
October, okay, so October 26th?
I can make 26.
You can make 26, Dr. Wesson? Okay. So let's go ahead and put down October 26th as our October meeting date. And I would like, if it's going to be October 26th, just so that they're not stacked on top of each other, December 7th, if that's okay.
December 7th?
December 7th. I'll give you a second to kind of get your calendar. You might be out of town. So let's go ahead and do October 26th, and let's get together on a December date as we finish up our 26th meeting. I mean, our September meeting. Is that okay? Yeah. So we'll put down a December meeting of some sort. Carla, do you have a?
Unrelated to the timing, if you'll just give me a moment before you adjourn. Sure. Thank you.
So confirm October 26th. Not confirmed for a December meeting, but we will revisit that in September. Okay?
Outstanding.
I would also like to take a second to thank you, everybody, for the criminal conviction guidelines. I know that's a laborious process. The LAR, which is just wonderful. Thank you for all of that. Some great initiatives there. I'd also like to thank our troopers for being here, providing safety. Thank you. It's good to see y'all and get to know y'all a little bit better. We'll be the same two gentlemen every time, you think? Above your pay grade? Okay, well, we got to show them where the donuts are, right?
That's right, that's right. Stash, we got
All
it.
right, there's a stash. So, staff, do you have anything?
I was just going to thank the officers as well. So.
Oh, okay. I'm sorry, Carla. I stole that.
No, you know what? I'm used to getting my thunder stolen, so it's perfectly fine.
Yeah. Well, thank you for taking the initiative to do that.
We have Nick to thank for setting that up.
Nick, thank you. Thank you. See, I would have just taken all the credit. I wouldn't have given Nick anything. All right. Well, if there's nothing else, I'll
Move to adjourn?
Move to adjourn after everybody tells me how great this part of the meeting went since Mike was gone.
Oh, it was so fast.
I mean, just moved right. All right. The meeting is adjourned. Thank you, everybody, so much.